In Air Transport Association of America versus Secretary of State for Energy and Climate Change, we'll see whether customary international law prevented the European Union from regulating greenhouse gas emissions in the aviation industry. In 2003, the European Union created a cap-and-trade system for greenhouse gases in the EU, known as the emissions trading system. Initially, the trading system only applied to stationary emission sources. However, in 2008, the EU adopted a directive that would include aviation emissions in the trading system, beginning in 2012. The directive would apply to all flights in and out of the EU, regardless of the nationality of the airline. Under the trading system, airlines would have to purchase allowances for every flight's greenhouse gas emissions. The emissions would be calculated based on the entire length of the flight, including emissions produced while a plane was flying over the high seas or non-EU countries. Many countries, including the United States and China, objected to the directive. In 2009, the Air Transport Association of America, American Airlines, Continental Airlines, and United Airlines filed an action in the Queen's Bench Division of the High Court of Justice of England and Wales. The association and the airlines argued, among other claims, that the directive violated international customary law principles, including a state's sovereignty over its airspace, the freedom of flight over the high seas, and the freedom from state sovereignty over the high seas. The High Court requested a reference for a preliminary ruling to the EU Court of Justice. Courts in EU member states may request a reference for a preliminary ruling on EU law issues to the European Court of Justice.